Stopped by the police and charged with DUI? I know it often feels helpless, but I'm going to talk about some ways the right attorney can fight a drunk driving arrest. Number one, every DUI is actually operating while intoxicated. Don't ever forget about the operation. So many attorneys see a DUI and they think, oh, we got to get this pled out immediately. But don't ever forget there's elements, operating vehicle while intoxicated. And while it seems obvious, operation, so many attorneys skip over that part. If the vehicle was not in motion, if the vehicle was parked, yeah, there are ways to get convictions, but if the vehicle was not in motion or was parked, it's going to be a lot harder for the state. So make sure the attorney is fighting the operation when appropriate. Number two, timing of the breath test. I'm not talking one at the side of the road. I'm talking at the station. The certified breath test or even the blood test has to be given within 3 hours of operation. So many attorneys just skip over that part, but the Court of Appeals has held it actually needs to be within 3 hours of actually controlling the vehicle. So driving. So again, if the vehicle is parked, if the vehicle is at the side of the road, well, there's always 100% of the time, no exception, going to be an issue with the timing of that breath test. Yeah, there are ways for the state to overcome it, usually by a person's own admissions, so always plead the fifth, but the timing of the breath test is a giant part of every DUI case. Number three, the way the blood or breath test is administered. Blood and breath have to be done in an exact way, otherwise the results are not admissible. And it says that in the statute. If done in a weird way or a way not supposed to be done, it's out. There's no leeway, there's no wiggle room. Do it correctly or don't do it at all. Now, the actual way to administer the blood or the breath test is in the Indiana Administrative Code. Most attorneys don't even know the administrative code applies in a DUI. Stay away from those attorneys. For the blood test, it has to be done pursuant to a protocol prepared by a physician and approved by that physician. Now, that might sound nitty-gritty, but I have won so many cases where officers are not following the procedure for the blood or the breath test. And the prosecutor is never going to be like this, oh, excuse me, we didn't do it right. That never happened. Doing this job for almost 20 years. I've never had a prosecutor say that. I've always had to go out and find the evidence. I've always had to go out and get the evidence from the hospital, the officer. Nothing's ever been given to me. I got to fight for it. So make sure your attorney is fighting for you. The fourth way, Miranda warning violation. Now, a lot of people call this office and they say, Mark, they did not read me my Miranda rights. I need you to get the case dismissed. It's never as simple as that. But if a person's in custody and they're being interrogated, the Miranda rights jump into action. So what's in custody? If you're handcuffed, you're in custody. If you're not free to leave, you're in custody. What's interrogation? The officer's asking you questions. So one of the ways we see this happen all the time is if there's an accident. There's a case in Indiana, Moore v. State. If there's an accident, people can't leave the scene. It's a crime. So they have to stay there. They're under arrest, and they need to be given Miranda warnings. We also see this with the smell of certain substances that are still illegal in Indiana. And if officers smell that, well, the law in Indiana is you're not free to leave. Officers need to be reading Miranda warnings. It can get nuanced, and it's not as simple as they didn't read my Miranda, so the case gets dismissed. It's not that simple. But when the police are supposed to read it, it can be very important because if they don't read it, the things you say are not admissible. And so make sure your attorney is fighting any type of Miranda warnings violation. They're fighting for it and they're looking for it. So many attorneys just give up on DUI cases. Not too much we can do. There is so much to do if they know what to do. The fifth way, the training of the officer for the standardized field sobriety test. Standardized field sobriety tests, those are the HGN, the one leg stand, the walk and turn. I like to call them stupid human tricks. They have to be done in a certain way pursuant to National Highway Traffic Safety Administration. So many officers get the training in the academy and they don't do anything with it afterwards. So they're giving these tests incorrectly. They don't know what they're doing. They don't know how they're doing it, but they're simply cutting corners. Now, a lot of times, an officer doing the SFSTs poorly is still saved by a blood or a breath test. But if we can kick out the blood or the breath, then the evidence of the SFSTs, the HGN, the walk and turn, the one leg stand, is going to be what's going to be used against you to convict you. So an attorney has to know both the blood angle and the SFST angle to give you the best shot of having a happy ending with your DUI case. There are tons more, and we'll do other videos on this, but these are the top 5 ways that I see. Be on the lookout for a second video shortly. If you or a loved one has been charged with DUI, OWI, OVW, whatever you want to call it, it's all the same thing here. Give us a call here at the Marc Lopez Law Firm. We take DUI defense, we take it passionately because we love helping people who are in trouble. right? I'm a giver. If you have any questions, give us a call, 317-632-3642. But most importantly, remember to always plead the fifth.